So this is a probation violation hearing. Mr. Elhart, you've been retained now to represent Mr. Foz. Are you prepared to go forward with the hearing this morning?
Yes, sure.
Okay, so Ms. Traska, if you could please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth? So help you God.
I do.
All right, and if you could please start by telling us your name and how you're employed.
Amanda Traska, probation officer for Leelanau County with District Court.
Hang on just a moment, Mr. Elhart.
If I may, Your Honor, Mr. Foz is here to admit that he is unable to do the community service work.
Okay, so he wants to enter a plea.
Yes, Your Honor.
What about the added violations for, let's see, failed to continue counseling with the cancer center, disrespectful of court employees and care providers, and acting in a threat, intimidating, harassing manner. Okay, so then, Mr. Foz, is that correct? You're changing your plea in this case to guilty of the violations. That's what you want to do, is plead guilty.
That's his direction, yes, sir.
Okay, so it's still your decision, but I understand you've consulted with Mr. Elhart, and that's what you've decided to do.
Yes, sir.
Okay. So before I take your plea, I want to make sure you understand that you do have a right to a hearing at which Mr. Elhart would represent you, and you're choosing to waive that right, correct?
Yes.
You also understand that the worst that could happen is for this conviction of leaving an accident causing injury is you could be sentenced to up to a year in jail.
Right from the jump, this case hits like a freight train. We got a defendant who claims disrespect on the road turned into him using a truck as a weapon, and somehow, in his mind, he's the one who ended up wronged. And here's where it gets wild. The court originally showed mercy. Medical issues? Considered. Jail time? Suspended. Probation instead? Granted. But instead of taking that second chance and following the rules, this man allegedly turns around and starts clashing with probation officers, court staff, and anyone who doesn't bend to his will. What you're about to watch isn't just a probation violation hearing. It's a slow-motion unraveling of a mindset where accountability feels like a personal attack.
I'm going to say no, sir.
All right. Then the report indicates you were placed on probation back in October of 2023 for leaving the scene of an accident causing an injury. And as a condition of that probation, you were to complete 30 days of community service work within the first 180 days. Is that true?
Yes.
And the fact is you did not complete the 30 days in the 180 days, correct? There's also an allegation that you failed to continue your counseling with the cancer center as ordered. Is that true?
True with extenuating circumstances. It's not true that I refuse or I'm not doing it. As I've mentioned before, a letter was sent from the parole office without my permission or knowledge to my medical providers asking for information on my medical records. When I found out about that, I called my medical provider. They said they deleted the email. Right, this went on for about 3 months, me trying to get the email from my provider. She went to legally refused. And because of that letter that was written by the probation department and my asking about it, they discontinued service. They refused service because they didn't want to get involved in a legal case. I also went to my
Okay, so I'm going to give you and Mr. Elhart a full opportunity to explain the circumstances of these violations. But for right now, I'm just trying to establish if you're pleading guilty to this. For whatever reason, you did not complete the counseling that was ordered through Cowell Cancer Center, correct?
Correct, but not due to my circumstance, due to their circumstance.
The answer is yes.
Yes, sir.
Okay. So Is it also true you were disrespectful to court employees and or service or care providers?
I was honest with them.
Okay, but would you agree that you were disrespectful to them?
To me, sir, that's a very subjective term.
Well, we can have a hearing on that issue.
This is a critical turning point right here. What looks simple on the surface, he wants to enter a plea, actually carries a ton of weight. At this moment, the defendant has a choice: fight the allegations or admit to violating the very conditions that kept him out of jail. And notice the nature of the violations being discussed. Not just missed community service, but accusations of harassment, intimidation, and mistreatment of court staff. Those aren't small technical errors. Those are behavioral red flags. The court isn't just checking boxes here. They're assessing character, accountability, and risk.
I suggest we go with the three that you've admitted to, and you can take into account whether or not you think the board is appropriate to consider for any sentence.
All right, so Mr. Alhart, are you okay with that?
I am, Your Honor.
All right, so then, Mr. Foss, to the first three allegations, how do you plead?
Yes.
Okay.
I'll accept your plea, find it is voluntary, accurate, and understanding. And Mr. Alhart, what else would you like me to know?
Thank you, Your Honor. I'm in the sentencing phase now, Your Honor.
Yes.
Thank you. Your Honor, Mr. Foz was, and you had received it, I think, a copy of a letter dated nearly a year ago, where he was given 2 years to live. He may not make it to his next birthday. He's under daily chemotherapy. Cancer has spread to his bones, the rest of his body, and the liver is at correct lymph nodes. I'm sure that he's undergone great deal of modifications to his temperament, the way he behaves, and everything else due to the cancer. I'm very certain in looking at his history and talking to him about his history, what he's done for our country, that he was an exemplary citizen. Cancer has changed who he is and what he is doing. His behavior many times inappropriate. Certainly, I understand his dismay that his medical rights were violated. By the same token, I understand what was going on. He can't do any work of any kind. He can barely make it here today.
Mr. Alhart, are you aware that he was given the opportunity to consult with the probation agent to try to come up with non-physical activities that would count as community service work, such as writing letters to veterans?
I wasn't aware of that.
I wasn't aware of that either, Don. That's never been proposed to me.
Right here in open court. Okay, go ahead, Mr. Alhart.
What was right here in court, Your Honor?
When we were here on the first probation violation. Okay, thank you. Mr. Foss, is there anything you'd like to add?
Yeah, there's a lot that I'd like to add.
This moment exposes something really important, and honestly, really dangerous. The defendant claims he doesn't understand how probation works, even after already going through trial and sentencing. But legally speaking, this isn't confusing. Probation is mercy. It's a deal. You follow the rules, you stay free. You break them, the original jail time is back on the table. The judge is doing his job by laying out the worst case scenario. And the fact that the defendant sounds blindsided by this tells you a lot about his mindset. He didn't see probation as a second chance. He saw it as a right. That disconnect is what lands a lot of people in deeper legal trouble.
Pushback like that. I don't think I've made any unrealistic requests. I'm not familiar with how the legal system works, but when I am refused service, it makes me a little irritated. I expect professionalism from my public employees, and I admit I've not been professional. I've been irate, and I get that way very easily. Part of it's, as we mentioned before, testosterone has a huge impact on that. It changes your personality. I had a doctor's appointment last week, and I mentioned that to my doctor. And he said, it's an effective testosterone. And the reason I'm unable to perform these tasks is because of my testosterone levels, my chemotherapy, my sicknesses. The reason I missed my last appointment for probation, and I mentioned this to Ms. Trask, I wrote her a letter. I'm very sorry I missed the appointment. I was ill. I don't get my mail every week. I apologized, and I asked her if there was something I could do to mitigate the situation. I never received a reply. So it's not that I'm fighting and refusing to do what you're asking me to do. I will happily do, if I could, sir, I would happily do what you asked me to do, but I'm not physically able to do it. I've mentioned that I would be happy to pay a fine to help out the community, but physical activity serves. Yeah, I'm not able to do it.
All right. Mr. Chamberlain, anything for the people?
Your Honor, I agree with Mr. Foz that the scales of justice are not equal in this case because he was charged with a felony and could have been charged with 2 others for felonious assault. Your Honor, he got mad at someone who flipped him off. He turned around.
Watch how the language shifts here. He admits he didn't complete counseling, but immediately reframes it. Not his fault, someone else's fault, the system's fault. This is textbook deflection. Legally, the court doesn't care why you didn't comply as much as whether you did. And the thing is, probation conditions aren't suggestions. They're court orders. If a program falls through, it's still on the defendant to communicate, document, and request alternatives through proper channels. Instead, what we're hearing are justifications layered on top of noncompliance. And when the topics shift to being disrespectful, he tries to redefine the meaning of disrespect rather than owning it.
In this case, and had he been convicted of just what was on here, he's looking at 0 to 14 months. Had we increased it to the 2 additional felonious assaults, it would be 7 to 23 months. That's OV1 for using a vehicle as a weapon, OV2 for the potential lethality of the weapon used, OV3 25 points for life threatening and permanent incapacitating impairment, OV4 10 points serious psychological requiring therapy and other medical intervention. OV9 number of victims, there were 2 to 9 placed in danger. OV17 10 points for driving recklessly, disregarding life. Your Honor, Mr. Foz thinks he's the victim here. You look at his information or the email, excuse me, and this is what he says for the victim. To be bluntly honest with you, my opinion is the legal system is fucked. My honesty lands me in hot water. Menendez dishonesty lands him thousands in cash. That's fucked, really fucked. Your Honor, the only reason why he got a misdemeanor was because if it was an intentional act, we were concerned that his car insurance wouldn't pay.
This is where the temperature in the room really starts to rise. The judge isn't buying the "I wasn't intimidating" narrative, and you can feel that shift. When someone denies behavior, but the court already has emails, reports, and statements queued up, that denial becomes less like a defense and more like fuel. Courts take threats and harassment extremely seriously, especially when they're directed at staff or victims. This isn't about feelings anymore. It's about documented behavior. And now the court has leverage. They can either accept a guilty plea on limited points or open the door of full evidence and tear everything apart piece by piece.
He could have done community service. He's been disrespectful to the court. He blames the court for everything. He blames the victims for his actions. I don't know what you should do, but I do know that he's a public safety risk because, as he said, he becomes irate and it's due to his medical conditions. Something has to be done. I don't know what it is, and I'm going to leave it to you to make that decision.
All right, so this is sentencing on a number of probation violations. Initially, the concern was fail to complete 30 days of community service work. which was intended to be in lieu of jail time, taking into account Mr. Fa's medical condition. And Mr. Foz was given the opportunity at the first probation violation. Well, it wasn't a probation violation hearing. We had a review hearing to determine how to go forward. And at that time, what I recall is Mr. Foz refused to provide any medical information of any substance so that I could even verify what his situation was and whether he was physically capable of doing community service work or not. He continued to give the probation department a hard time at every corner, even pursued them with FOIA requests asking for why his original probation officer, Ms. Hulse, left her position, FOIA requests to investigate them. And actually, my probation.
This is the emotional curveball of the entire hearing. The defense introduces serious illness, terminal cancer, limited time, chemotherapy, declining health. And from a human perspective, that hits hard. But legally, it doesn't erase what already happened. Courts do consider health in sentencing, but it doesn't act as a magic eraser. What the defense is trying to do here is shift the judge's perception from dangerous offender to fragile human being. It's a delicate balance. Sympathy versus safety. Compassion versus accountability. And you can tell the court is listening, but not losing sight of the original fact.
You asked if I would sign a release of my medical records. I refused. You lose. I will give you the letter of disability, which you didn't ask for. If you can't tolerate someone challenging your supposed authority, become a librarian. Government employees are pieces of shit, ignorant, lazy, don't do their jobs. You know, I don't care what you say about me, but you're talking to someone who comes in every day, does her job, tries to do the best that she can. And Mr. Elhart said something about, I know people with cancer. Yeah, I've got a mother-in-law who has terminal cancer right now. I can't imagine her, with as much as she's gone through the last few years, ever behaving in the manner that you have. So, yeah, that's just the tip of the iceberg. I wasn't aware of all of the disparaging statements that were made until reviewing for this case this morning.
Can you say something, Ryan?
No, it's my turn. The idea that the defendant was not able to complete community service work, as Mr. Chamberlain pointed out, is simply not true. He was given the opportunity, because of his health condition, to come up with ideas for how he would do that, including writing letters to veterans, including the suggestion of the Humane Society volunteer work that Mr. Chamberlain came up with himself, and continued to refuse to do that. He did complete 4 hours of community service work, I think at a thrift shop, maybe. So
This is the moment reality snaps back in hard. The prosecutor doesn't deal in hypotheticals. They deal in outcomes. And here, we finally hear what really happened. A vehicle used as a weapon, a person seriously injured, torn skin, hospital time, long-term trauma. Suddenly, the courtroom isn't about missed appointments or rude emails anymore. It's about blood, injury, and the real-world dangers behavior caused. The prosecution methodically lays out how this could have been charged more severely: multiple felonies, harsher time, weaponized vehicle enhancements. This isn't just storytelling, it's positioning. They're showing the judge this defendant already got mercy once, and he didn't respect it.
To get here in the first place. Mr. Chamberlain described a little of that. Basically, you stalked these two guys on bicycles with your car because you felt you'd been disrespected by them. You assaulted them with your vehicle and you struck Nicholas Mendez. And this is what he said at his in his victim impact statement. Looking back on the incident now, I realized I was in shock more than anything at the time, thanks to the help of the medical team at Munson and my physical therapist. I am able to be active and attend and return to life as a student. However, the experience was much more traumatic for myself and my family than I had thought at the time. My mother took off work and flew all the way from California to Traverse City to spend time with me at the hospital following my initial surgery. She was restless and losing sleep for the week that I was admitted and didn't seem to go back to normal until I was discharged and back home. My father was the same and also came to visit me and help me around my apartment while I was recovering. Luckily, I have friends that lived nearby that were generous enough to offer their time to help take care of me after my parents left to go back home. As for myself, the summer did not play out how I imagined it would. I missed nearly 2 months of a research experience at the Rush University Midwest Orthopedics Motion Analysis Labs position that I had spent half a year networking and meeting with different professionals.
At the end of the day, this case isn't just about probation violations. It's about accountability. The court gave mercy. The system extended grace. And instead of compliance, what followed were excuses, deflection, hostility, and entitlement. The judge had to balance compassion for serious illness with the very real risk this man posed to the public. And that's the heart of courtroom justice. It's not about feelings. It's about facts, responsibility, and protection. Cases like this remind us that second chances are powerful, but only if they're respected.